Thank you for the kind introduction and for inviting me to speak to you today about the children's rights and the General Data Protection Regulation. My name is Jutta Kroll. I'm coming from the Digital Opportunities Foundation in Germany, and I should have been accompanied by my colleague Isabel Rausch-Jarolimek. Unfortunately, she became ill yesterday morning, so I had to come alone, but I will tell you a little bit about the two projects that we are working on together. First of all, I will like to make you a little bit more familiar with the UN Convention on the Rights of the Child, and then I will continue to talk to you about the General Data Protection Regulation. Just to give you a short impression on these two pillars of the projects we are working on. Maybe some of you are aware that the Council of Europe has adopted the so-called Sofia strategy 1.5 years ago in April in a conference in Sofia. That's why it's called Sofia strategy. And there they dealt with the UN Convention on the Rights of the Child, considering how this could be interpreted in the light of new developments. And that's the main point I would like to talk about, that we can talk about child protection from a different angle when we take a look at the rights that are dedicated to children in the UN Convention on the Rights of the Child. And if you look at on the left side, you will see on the bottom, this strategy of the Council of Europe is based on 5 pillars, which is equal opportunities for all children, participation, a life free from violence, child-friendly justice. These were the traditional areas where children's rights are performed. And then for the first time, you see there, the pillar of digital environment was added to the strategy. And it was debated from the beginning whether digital environment is really a 5th pillar of children's rights, or whether it might not be like a horizontal area, which is affecting all the other areas of children's rights. And I will go into that a little bit more in detail. I don't think I shall explain to you this very complex graphic. It shows that there are 2 organizations, the Coordination Office for the Implementation of the Sofia strategy at the Deutsche Kinderhilfswerk, which is a children's charity in Germany, and then the project Children's Rights Digital, which is positioned here on the right side from your perspective, and you see that it has a lot of connections to all international and transnational organizations like the Internet Governance Forum, the European Governance Forum on Internet Questions, the ICT Coalition, the European Commission, and also ICANN, which is responsible for the Internet domain name. So there are a lot of relationships and close cooperation in that area. In the Coordination Office for Children's Rights, what does my colleague Isabel do in Germany? They are monitoring the implementation of the Sofia strategy from a technical and from a political point of view. It's done by the Deutsches Kinderhilfswerk together with the Federal Ministry for Family Affairs for over 3 years, and it's more or less coordination and implementation of different projects, and one of these projects is dealing with the General Data Protection Regulation. On the other hand, you have seen the project on the right side, which has the purpose to make visible what we are doing in Germany and to connect with all the other actors in the field of children's rights in Europe and across Europe and internationally. So I'm very glad to be here and to talk to all of you to learn how children's rights are understood in Poland and how this affects the digital environment. What we will do is developing a framework of interpretation for the UN Convention on the Rights of the Child, and I will explain that a little bit more in detail. The UN Convention was set up in 1989, then it was adopted by the United Nations, And this is, it's interesting that this was the same year when Tim Berners-Lee developed the code that made the internet accessible to everybody. So everybody could use the internet that was previously meant to be a network for research. So when these events happened both in 1989, nobody considered that children's rights would be in any way affected by digitization, by the internet in the hands of children. But now, many years later, we see that it's all interrelated. It's necessary to understand what the convention means when they speak about a child. Any person under the age of 18 is considered as a child in the sense of the United Nations Convention on the Rights of the Child. So I prefer to speak about children's rights and child protection and not to talk about youth protection or young people's rights, because in the UN Convention, everybody under the age of 18 is considered to be a child. And if you look at statistics, you will see that 1/3 of all internet users worldwide is under the age of 18. So we know that the internet is a medium that is highly used by young people, and therefore it's more than ever necessary to stress their rights when it comes to the digital environment. We understand as the digital environment everything that is available in a digital way. That means the services as well as the devices that you can take in your hand to connect to the internet or to use the services. And I think we will have another presentation this afternoon about Internet of Things. So you will see many devices that do not look like a smartphone or a computer, but they are now connected to the internet. And we see more and more devices that are toys for children that are also connected to the internet. So sometimes we also speak about the Internet of Toys, not only the Internet of Things. In the UN Convention of the Right of the Child, one of the in the prominent places is the right to access. So when this right was phrased, it was phrased to ensure that there is non-discrimination in regard of access, but still access was not meant as access to the internet. But now it's necessary to understand that this right, of course, is also the right to have access to the internet. Then it's obvious the right to freedom of expression and the right to information. Both these rights were phrased in 1989 with no thought about the internet, but today it's obvious that it's necessary to grant these rights also with regard to the internet. Then there are the rights to assembly, association, participation, and play. And also, as we heard in a lot of other speeches today, what children are doing is they associate with their friends over the internet, they participate in many activities over the internet, and also they play via digital devices. So all these rights need to be interpreted with regard to digitization. And I think if you remember that in former times, when there was a building with a certain amount of flats where families could live, there was a regulation that a playground needs to be built in the proximity of the building just to ensure that children could exercise their right to play. So it's obvious that nowadays we need to discuss what this means when play also takes place via the internet. Then the right to education and also the right to digital literacy. We've heard a lot about that today, that schools have the necessity to provide for education for children. It's their task, but they also need to do that with regard to digital literacy and to provide digital means for education. The right to protection and safety, also that is obvious, that we need to understand that children need protection and need safety when they use digital media. And for example, if you have a look at the UN Convention, there is the right to be protected from sexual abuse, from exploitation, the right to be protected from violence, And all these rights need also to be taken into account. What does it mean with regard to the internet? Because we know that violence, that sexual exploitation and sexual abuse also takes place in digital media. And then the last point, the right to privacy and the right to data protection. Also, these human rights are specially dedicated to children. And now when it comes to the General Data Protection Regulation, we kind of see that these might be conflicting interests. On the one hand, we would like to ensure that children have their data protected, and the Data Protection Regulation makes that very clear. And on the other hand, we also see that there might be a conflict with their right to access, with the right to freedom of expression and freedom of information. So the General Data Protection Regulation will come into force in May 2018 on the 25th, and it then is law in all European countries. So national governments need to have a look in their data protection regulation, whether it's fit for purpose for the General Data Protection Regulation, but it's not like in some other directives, for example, where then you need to have a law to implement it. It becomes directly law in the European countries and in all European countries. For the first time, such a regulation mentions explicitly that children have a right to be protected in regard of collection, storage, and processing of their data. The GDPR does not allow profiling of children, and it does not make very clear at that point where this starts and where it ends. It's important that all collection, storage, and processing of data needs to be based on the legitimate interest, and that needs to be a balanced approach. So once the data subject, which is the person, the individual like you and like children, has a legitimate interest that their data are collected, stored, and processed, or are not collected, stored, and processed, this needs to be balanced to the legitimate interest of the data controller. That means, for example, the company, the government office, or some organization else that would say, okay, I need to collect these data to perform the tasks that is foreseen for me. So, and this needs to be balanced because in some cases there could be a conflict between these two legitimate interests. The GDPR also puts high emphasis on transparency, and that is also important with regard to children. For anybody whose data are collected, stored, or processed, it's necessary that they are informed for what purpose this is done, and then also what happens to their data. And when it comes to children, this needs to be made apparent and comprehensible to children. So when I said previously, children are from birth to 18, you will understand that it's very difficult to say, okay, what I can explain to a 16 or 17-year-old about their data being stored and processed, a 5 or 6-year-old child would not be able to understand. So the GDPR sets a threshold at the age of 16, and this is manifold debated across Europe with many stakeholders, whether this is the right age to say, okay, up to 16, children will not be allowed to make use of information society services, and that is everything you find on the internet, except their parents have given their consent to that usage. And then, and that is the tricky situation right now, the GDPR sets the option for national governments to decide and say, okay, maybe in Poland we think 14 is a better age threshold. Then a national law could set this different age threshold. It could not go beyond 13. So the already known age threshold that you all know from the services like Facebook and so on, that is 13, You could not go below that and say maybe all the children in Poland are so mature they can use and decide on their own at the age of 11 or 12. That would not be possible, but it's a corridor between 13 and 16 where national governments can decide. So I've quoted here from Article 8 that sets the condition applicable to child's consent in relation to information society services. And I won't read it out to you. You can all read it yourself on the internet. It says that a service, an information society service directed to a child. So, and this is still debatable, what does it mean? If in the terms and conditions the provider of the service says, my service is only for people aged from above 16, or like Facebook says from 13, above 13, then is it a service directed to a child or not? If we all know that children will use these services, or at least will try to use these services, it might be the case to say, okay, then the service is directed to a child because they will be able to use it. Then I said before, national governments can decide different and say we have a lower age threshold. And also the GDPR says the provider of the services shall make use of the technical state of the art to ensure that it's really the parent that gives consent that their child is using the certain service, and also their state of the technical state of the art. It's debatable what is technically possible or not. So we've collected some questions that could be discussed. We don't know now how many parents, how many teachers and children themselves are aware of the upcoming new regulation as of May next year, and what consequences that would have on the usage and on the offering of services to children. We don't yet have a strategy how all people can be informed and prepared in an optimal way. We know that more stakeholders than before will need to have more knowledge about privacy, data protection and consent. It's a question what role NGOs can play, what role schools can play in informing people. As I said before, it needs a definition what the offer of information society services directly to a child will mean in words. And we already have acknowledged that there is a slight difference in the German and in the English version language. I don't understand the Polish version, but this directly to a child could be phrased a little bit in the different language versions, and then it needs more interpretation which services are really affected. Parents would need to be educated to give their informed consent. They need to understand what it means when their children do use services, information society services, so web applications, also apps they have on their smartphone or tablets. Even the term personal data is not yet clearly defined, and some people debate that even the IP address that is transferred when you have access to a website could be considered to be a personal data, and then it would fall under the regulation. Then it's not clear what will happen if someone gives their consent to the usage of their children involuntarily, just not understanding to what they have consented. Even though the regulation demands for transparency, it could happen that you agree to something that you could not look through properly and you don't understand what the consequences are. Also, children will try to cheat about their age, as they already do so when they are 11, 10, 12, and they would try to use Facebook, WhatsApp, or any other service. And then the question is, who will be responsible? The parents who haven't taken care that the child doesn't cheat, or the service provider who hasn't properly verified that the child is really old enough and has the consent of the parent. And then always also it's necessary to discuss the potential limits of media literacy and data literacy education in this regard, because I think you all know situations where you are not sure to whom you have given away your data in a certain, when using a certain service. And it might be the case that you also agree to your children using a service, and afterwards you are not sure to what you have consented. And I'm not sure whether this could be addressed by media literacy alone. It will definitely need to be supported by technical tools, by explications, by training, and so on, that people get aware of what the GDPR really means. So you've shown me the time sign already. I think I will leave it at that point, and maybe, I know I have raised many questions. Maybe you have more, and I will try to answer them. Thank you.